This is another area where almost every week I speak to landlords who are far, far, far too generous. And this is not what the press say about us. This is not the public perception of private landlords. But every week I will speak to landlords who are just far too generous around lack of rent increases or the rent level they offer. And I'm constantly encouraging landlords to correct that issue for a number of reasons that I will come to. But this has now become another reason for landlords to correct their rent levels. So the specific change is that rent increases can no longer be informal. Any rent increase placed upon a tenant must be accompanied by a Section 13 notice, it's the legal notice to change the rent level on a tenancy. As a letting agent, we have always issued that document as good practice, but there are some landlords who simply agree increased rent levels by discussion. That's never been our operating sort of way. We would always have issued a Section 13. But this legislation makes it mandatory that a Section 13 must be issued. A Section 13 so rent can't be increased in the first year of the tenancy. So there's a veto within the first year. And landlords now must give 2 months' notice to increase the rent, not 1. So at the moment, until May, landlords can increase the rent by giving 1 month's notice, not 2. So that's the first major change. And landlords can only increase the rent every 12 months thereafter. Now, that is usually common practice anyway, so probably not a major change or deviation. But the key thing for me is what I'm going to come on to around if a tenant is not happy with your rent increase, they are now able to raise a tribunal case, and it's a free process for tenants. And what would happen, so say we've raised someone's rent to £1,000 a month, we've given the Section 13 notice and that we've correctly given 2 months notice, but the tenant objects. They can apply for a first tier tribunal, and the rent increase is in effect frozen. So until the tribunal has the hearing, you do not get your increased rent. Now, the timeline for a tribunal is 4 to 6 months. And even if it is successful, the increased rent is only effective after the hearing. And then your next rent review can only be 12 months thereafter. So if I were a savvy tenant, even if I agree with the rent increase, I would apply for a first tier tribunal because it's free, so why wouldn't they? They would save 4 to 6 months of the rent increase because it can't be applied until the hearing. And they've delayed the next rent review by 4 to 6 months because it's pushed the boundaries on. So these are further sort of restrictions that are placed upon landlords by this legislation. So a big campaign that I am now having is to educate landlords and say, if you are one of the many landlords who has not reviewed rent for years and knows that tenants are significantly underpaying, now is the time to initiate a rent review under the current regime. To get that done in the next 3-4 months and correct the rent level as much as possible within that window. Because post-May, you will be in this new regime, and tenants will undoubtedly take advantage of the first tier tribunal. They will delay that rent increase. It will be more work and effort for you to prove that the rent that you are trying to charge is a fair and proper rent. So in terms of that, what they're saying is, as a landlord, you would be asked to present your case as to why you should be entitled to the new rent that you're proposing. You know, you have to prove it's a fair market rent. There's even suggestion that you would need to have evidence that a rent asking price isn't sufficient. So Rightmove adverts may not be sufficient because there's an argument that a property that's advertised at £1,000 may only be rented at £900. So it's easy for us as agent to access data on the actual rent that's been achieved on properties, but more difficult for private landlords to access that kind of data. But there is suggestion at the tribunal they'll be looking for not adverts, but what rent was actually achieved on property, that would be the comparator. So there are now a number of complexities for landlords in terms of how they would defend themselves in this case. And what we're told is that at the hearing, the rent can never be increased above the rent you've proposed. So if you proposed £1,000, it would never be increased above, but the tribunal can decide that a lower rent should be set, so they can reduce it. But if you'd actually set the rent too low, still they can't go above. So it would be capped at the number that you had raised the rent to. So again, this is one of my big messages to landlords. There is now this window of opportunity. If you are one of the many landlords who is just too generous, I can't believe I'm saying it, but so many landlords are far too kind in how they deal with their tenancies and the rent level they set. So if that is you, there is this window of opportunity to correct rent level and raise rent within the next few months, and you would be in the current regime with 1 month's notice. So at AMRP, it's something we do every year. It's part of our regime. For landlords that we assist, we are actively encouraging them to look at this as an absolute matter of urgency. This must be looked at in the next 3 to 4 months under the current regime to correct rent levels that are lower than they should be. So that's something I will leave you guys to soul search. If you are a landlord and you have tenants who are below market rent, there is a critical opportunity now to correct that. There's a time window when that can be done. Otherwise, you will be in this new regime of having to issue the proper legal notice, of being subject to potentially being taken to tribunal to dispute the rent that you've proposed. And certainly clever tenants will take advantage of the delay. Excuse me. Certainly clever tenants will take advantage of delaying that rent increase, even if they agree with it. So record keeping will be particularly important. Certainly when we do a rent increase now, we create a file of how we've come up with that rent level. So if we ever are challenged, we will have the file ready to say, well, actually, these were our comparables. This is what we compared to. This is why we felt it's a fair rent. Here are a number of properties of the same size, same location, and same postcode area at similar, that have achieved similar rents. So we would be ready to defend the rent level that we've proposed. But this is going to be a real challenge for self-managing landlords to have all of that paperwork and evidence to hand. But this is the kind of paperwork and preparation that landlords are going to have to hand. But I think the big message is, and I really can't stress it enough, I do speak to so many landlords for whom this is an issue, and really now there's a small window of opportunity to correct that. And what I'm just going to touch on is some of the reasons I often state to landlords why they really should think about rent level and get it close or near to market rent. Is we see landlords who don't charge full rent but they can't invest in their property. And of course they can't invest in their property. They're not collecting full rent, but they're incurring all the cost of a landlord. So, when a boiler breaks or there's repairs required, we see landlords who are then struggling financially. And it really is a self-fulfilling circle. If they aren't collecting proper and full rent, then of course they can't reinvest in the property. It makes absolute sense. We see landlords who have problems with remortgaging. So, for example, if you need to remortgage tomorrow, the mortgage company will look at the repayment you're going to pay and the rent you're collecting, and they have standard ratios as to what's acceptable. So we've had landlords who've come to us for help because they can't now remortgage because the margin isn't there between what they're going to pay and what they're going to collect. So it can cause mortgage problems. And I increasingly see this at the point of sale. So even this week, we are liaising with a number of clients who aspire to sell. And what I'm having to say to them is, to get full value for your property from a buying investor, we must collect your rent level, because it's so with MRP, it's a part of the big business that Chrissy and I work in every day, where we're working with landlords who want to sell and landlords who want to buy. Obviously, the buying landlord is particularly interested in the financial return they're going to get from the property. It's part of the reason they're buying the property. So if the property is under rented by £100 a month, it diminishes the future value of the property to the investor. So the offer they will make is lower. So just in the last week, I've engaged with a number of landlords, and the action plan we have devised is that as a letting agent, we will work with them to engage with tenants and correct rent levels. Then we will present those properties to sale to our investor database, because once the rent is increased to or close to market rent, we can then achieve the best possible sales value for that landlord. But whilst the rent is lower, we've just devalued the asset. So there are three major reasons, and there are many more, but there are three major and significant reasons why landlords really must. I know it feels mean. I know you don't want to do it. You want to look after tenants, but you are cheating yourself if you don't insist that tenants pay market rent. And as a letting agent, it's something we do. And we can't feel mean about it. It's business. And when a landlord has a bill to pay or an improvement to be made in the property, that tenant will require that of you. And therefore, why shouldn't you have the financial benefit of the full rent level in the interim? So I hope that's persuaded landlords who are just too kind. Stop being so kind. Tenants must pay at or close to market rent. They are just some of the reasons, but Renters' Rights Bill is now another reason, based on the restrictions I've described, why it's going to be really important to keep rents at the right level. And if you aren't at the right level now, take the window of opportunity. Take the window of opportunity in the next 3 months to correct that problem. Now, there is a call book and link, Chrissy, which is the rent review appointment, so a slightly different call. But if anybody feels this is an issue for them, and you perhaps know you have tenancies that are at rent levels far below where they should be, feel free to book a call with me, because there is this window of opportunity before we hit more complexity after May. And this, I think, will be something that we will really promote to landlords in terms of, this is a big action that you can take in the next 3 months. Frankly, protect your income, get rent levels to the right level, do it now whilst you possibly can before things change.